at the spur of moment. Finding is recorded, no motive, no previous enmity, single blow on the chest, which resulted in death. My lord, this is in fact a fit case to bring it under. And I'm not saying that it's a case for acquittal, but our request is that it can be brought under, my lord, part 2 of section 304.
You say 8420.
And the petitioner himself was also injured.
What was this IA for 10225 for bail?
It was for bail. It was not pressed at that time. Yes. So
you know why? Accidentally, I was also part of that bench.
Yes, well, I was not there on that date, but my lord,
we were not inclined, and this is the normal strategy adopted.
And my lord, in all fairness, my lord, there is an order of your lordship that if your lordship will kindly see the order dated
3420.
that my lord, at least you should undergo half of the sentence.
Yes.
It comes to about 3.5 years. So my lord, my request is that
it is for life, no?
7 years. 7 years. He has been convicted under 304 part 1. So my request is that your lordship may consider, because it requires consideration whether it can be brought under part 2. And my lord, considering the earlier order that my lord, he should undergo at least 3.5 years of sentence, your lordship may fix the matter in April 27, after 1.5 years, for the purpose of bail.
This matter in the 4th week of April 2026.
In the meantime, may I request for grant of leave? So far, leave has not been granted.
We'll see. On that day, if possible, we'll try to dispose of it. That is the only short issue.
Yes.
Part 2, you wanted, it's part 1. We'll see. On that limited issue, if we are addressing the argument, we may dispose it off.
Very well.
Okay?
Yes.
Next. Item 3.
Yes, my lords may pass it over.
What is this? Repeatedly, this is that Muskan Radha.
Yes, Your
Also.
Obliged.
Item 4. Yes, madam.
Yes, I have moved the application placing on record the medical certificate. Mills, the petitioner has enlarged prostate.
Yes.
He has a seizure disorder and hypertension.
Who is appearing for the state?
Should I appear for the state?
Yes.
We filed a counter affidavit also, I'm not sure.
Mills, the custody certificate starts at page 97, Your Lordships.
What is this? Not working. Mouse is not helpful. One second.
Yes, please.
Up to court number 10, all these things they give all second hand. These are registry officials. It's not your problem, it's our problem. Up to court number 10, they will give all used, which is not. 10 and above, it will be good. 5 and below, it will be extraordinarily good.
The Lord says a very gracious and holistic judge. Millards, it's really a privilege.
You have to bear with all these things.
Sorry, Millards.
No, why should you say sorry? Yes.
Millards, the petitioner is 75 years of age.
Correct.
He was working in the border roads organization. Millards, it was a family incident.
The matter is still pending before the appeal?
Yes, please, Your Lordships. There is no date yet.
Rightly so.
Would Your Lordship consider granting him the relief?
After 10 years.
Millards, he has.
Still complete 10 years.
Millards, almost 80 years.
Yes. After you renew a request after 10 years.
Millards, may I just say this, Your Lordship, that Millards.
It was not a sudden and he had a fight in the morning, went back, again came back with a rifle, with a gun in the evening, and shot him. It's a clear case of premeditated act of crime.
Minutes on merits, if your minutes, it would fall under 304. My respectful.
How can it be, madam? You can turn down your request. You have your say in the appeal before the High Court.
Minutes, may I just make another plea? Minutes, just in so far, minutes, minutes, he will be of no, minutes, if he's out now.
He is a military personnel,
Yes, please, ma'am.
more dangerous.
Minutes, he was a driver in the BRO.
Then why did he have the rifle? Why did he go after fight? If it was only it ended in a fight, right? He finished the fight, went back, brought his revolver in the evening. That means from morning 8:30 to evening 5 o'clock, he thought over. He thought that he should execute him, kill him, murder him, brought the gun, loaded gun, shot him in point blank range when he was sitting with his family members.
Minutes, the version of the petitioner is that he was told that he will be asked to leave by giving a garland of shoes. And that provoked him, and that probably that.
Take your chance in the High Court.
Minutes, may I just say this? He has been, Minutes, Your Lordship was kind enough to issue notice because Your Lordship saw this, that he needs this indulgence from this Honorable Court. Minutes, 7 years, 10 months, and 12 days he has been inside, Minutes.
Yes.
Minutes, may you kindly consider granting him some sort of a relief. Minutes, he hasn't been with his family all these years. Minutes, he's almost. Is all the ailments that are age-related now, Milods. Very grateful, Milods.
With these medical records, did you approach the High Court?
Milods, he
have not
approached this Honorable Court, Milods. He have not approached this.
Not approached.
Milods, the only relief that...
We'll grant you liberty to move the High Court. All right? The learned counsel appearing for the petitioner has brought to our notice certain medical records and claiming these aspects to be subsequent events which has emerged up to the rejection of the prayer for suspension of sentence and grant of bail. Move the High Court for grant of bail by considering the application and the medical records. The present petition stands dismissed.
Milods, may I just make another prayer that Milods, that his appeal be expedited?
There's an application pending. We have filed an application for that, Your Lordship.
First you take this. Why do you want to? You may get a bail, we don't know.
Okay, very grateful, Milods.
Oh.
For Your Lordship.
Item 5. Yes.
Milord, the service is complete on both the respondents. The state has filed its counter affidavit, but the private respondent has not filed their counter affidavit or entered appearance. The service is complete though.
Yes, tell us.
And it's could this service be, Milord's, I don't know if it can be heard because regarding suspension, very well, Milord. Milord, the state.
You are the
Yes,
complainant.
I am the complainant, Milord.
Yes.
The victim, actually.
Yes.
Because the state has filed its counter affidavit, they support my stand, Milord. They support the SLP. This is a case under POXO, Milord. The respondent, because he was
medical evidence is not in favor of in the case of prosecution.
Milord, I would say partly it is there, Milord, partly it is not. And in fact, the consideration that she did not have any external injuries. Milord, she was thrown on the ground in the fields. Milord knows that in a field, she will not get any external injury. When you fall on the mud, there'll be no injury caused because she fell on the mud. And admittedly, she is under 16.
No bloodstained clothes were seized.
Yes, Milord.
No spermatozoa was found on the vaginal swab.
Milord, all that is there, Milord, the medical, because also, Milord, the medical...
That is why the High Court has granted the bail.
Because the High Court has suspended the sentence on four grounds, Milord. That it was unnatural for the accused to bring the victim salvar. 2, that there was no blood found on the body of the victim. 3, that there is no injury on the victim from being slammed on the ground. And 4, that the salvar was not handed over to the police. These are the 4 grounds, Milord, on the basis of which the respondent, the sentence has been suspended.
Anything else?
My lord.
Having heard the learned counsel appearing for the petition, we do not see any good ground to entertain this petition. Dismissed.
My lords, may I request that the appeal be expedited, my lord? I may take my chance there. The appeal is taken up.
The learned,
This is a POXO case, my lord. That's the only reason. My lord.
the jurisdictional high court may expedite the hearing.
Great.
Item 6.
Beautiful.
My lord, this is the regular bill, my lord, and it is about the 4 years custody. And on the last, my lord had asked the death certificate of the complainant, my lord. I have filed at the page number 89, my lord. The complainant has been died during this trial, my lord.
Complaint is examined
No, complainant has not examined, my lord.
after the examination of the complaint.
No, complainant has been died, my lord.
Huh?
At page number 89, I have filed the death certificate. On the last date, my lord has asked the death certificate.
Yes.
So at the page number 89.
ET,
89, my lord.
who is appearing on the other side?
No,
Who
it
is
is press
appearing?
matter.
Huh? Press matter.
Press matter.
Notice.
Much old.
Item 7.
Yes, this is for regular bail, my lords.
My lords, I'm seeking 3 weeks time to file the counter evidence.
My lords, this is for regular bail. I have been implicated based upon the confessional statement of A1 to 3, my lords. Recoveries were made from A1 to 3. As on today, my lords, charge sheet has been filed. There are 31 witnesses, my lords. And out of that, none of the evidence has been examined, my lords. And he is in custody for the last...
What happened to the Periswamy, Pradeep Kumar and Bhaskar? Have they been released on?
No, my lords, they are also in the prison. Their recoveries were made by from them, my lords. They are also in the prison. No criminal antecedent on my part, my lords. As per the charge sheet, my lords, charge sheet says that
Charge sheet is filed.
charge sheet has
They are
failed
in custody from 1 year, 3 months.
1 year 7. 1 year 3 months, my lords.
What do you say?
My lords, CDR records are there which establish.
Sorry?
CDR records are there, my lords, which establish that he was coordinating with the.
After all, there is employees.
My lords,
It's a truck, is it?
yes, my lords.
Many a times, in these trucks, what they do.
They load.
Drivers and cleaners, in between, one stop to another stop, they stop and pick up something. They make some small monies. Somebody would have given up. We don't know. All possibilities are.
My lord, but CDR records are there, my lords.
We consider. Naturally, his employee would be.
No, my lords, he's not A1's employee. The CDR records are with A1.
This is item 7, no?
Yes, my lords.
He also
He's the
claiming on the ground of.
He is the employee of A4, my lord, not A1.
Medical insurance.
Oh, I know. He is A4.
Yes, my lords. A6, my lords. He is A6. He's
One
the
month.
employee of A4. Not A1, my lords.
Correct.
And
1 to
with-
3 are not released.
yes, my lord.
1 to 3 are not released.
Not released.
Yes. And he is also claiming on medical grounds.
This I have annexed the document.
Prison hospital record itself would show chronic obstructive pulmonary disease.
My lords, grant 2 weeks time.
For what, sir? Bail matters, you would have filed your objections before the Sessions Court and the High Court. What counter here? In this court, there will be no further counters for respondent. If you have filed, we'll take it. That's all.
There are CDR
On
records.
that ground, we will not adjust the matter.
No, there are CDR records, my lords, with
We
A1.
will consider. CDR naturally, as an employee, he would have
Not employee of A1, my lords, A4.
A4. What is the connection between A1, A3, A1, A2, A3, and A4?
They're all working cohorts, my lords.
Heard, you granted. Petitioner who has been arraigned as accused number 6 is said to be the owner of the vehicle, which was intercepted by the police and found the inmates of the vehicle were carrying 110 kgs of ganja.
120, my lords.
110 or 120?
120.
120 kgs, which was more than the commercial quantity, market 20 kg, market close. The petitioner, who has been arraigned as accused, was apprehended on the basis of the statement made by A1 to A3. Petitioner has been in custody since 1 year, 7 months. And after completion of the investigation, charge sheet has been filed. The learned counsel appearing for the petitioner has also contended that the medical records of the prison hospital itself would indicate that petitioner is suffering from chronic, single inverted comma, chronic obstructive pulmonary disease. Unquote. And now this ground also he seeks for grant of bail. Having heard on the other hand, the learned counsel appearing for the state would strenuously oppose the grant of bail by contending that the CDR records would establish a clear link between accused number 4 with the present petitioner, bracket accused number 6, and also the call details records of accused 1 to 3 and the petitioner. Hence, he prays for rejection of the petition. Having heard the learned advocates appearing for the party, and for the limited purpose of examining as to whether the petitioner would be entitled for grant of bail, we have perused the records. It is an undisputed fact that based on the co-accused statement, the petitioner herein was the owner of the vehicle from which the CDR by itself would not be the ground on which the continued detention of the petitioner would be warranted, particularly in the backdrop of the investigation having been concluded. That apart, the medical condition of the petitioner would also warrant further treatment which can be obtained by him outside the prison. What is his age? Odds are minimum in criminal cases. These are the basic facts you don't.
41 years.
Huh?
41 years.
41 years. For the cumulative reasons apostate, we are of the considered view that the petitioner is entitled for being released on bail. Hence, he is ordered to be released on bail, subject to such conditions and restrictions as the jurisdictional court may deem fit, and also subject to the condition that the petitioner shall appear on all the dates of hearing before the trial court, except exempted for any justifiable reason by the jurisdictional court.
That's 1 year, 4 months.
1 year, 4 months. Next.
Item 8. May I please, I appear for the petitioner. Though a similar matter has been disposed of earlier, dismissed. But if my lord will permit me, I want to place page number 40, which was impugned in the writ court. The entire selection process was over, and then the NCL has cancelled the selection process itself without assigning any reason whatsoever. My lords have held in S. Shankar Das case, constitution bench judgment, that though they have the power to cancel the selection process at any time, but at the same time, they should not act as arbitrarily. They do not have license to act in such a manner. This is the only point I had raised earlier also, on this time also.
Having heard the learned counsel appearing for the petitioner in detail, we are not inclined to entertain this petition both on the ground of delay and on merits, hence dismissed.
Item number 32 is same item, same matter.
Same matter,
32.
same order.
32.
Same points. 32.
So good.
Item 9.
With my Lord's permission, my Lord, similar impugned order notices have been issued by this honorable court.
That is the state of Rajasthan.
State of Rajasthan, my Lords.
One leg disability. One leg disability, 40%.
My lords.
Notice.
Very well. Deep-
Contempt is there?
My lords?
Contempt is there?
No, my lords, in this contempt is not.
Notice.
My lords,
Post, tag along with SLP, diary number 2816 of it.
Was dismissed.
no, notice was issued.
Note was
Notice was issued.
2816 of 2025.
My lords, may kindly condone the delay.
How much? Condone.
Very well. Deeply obliged, my lords.
Second tag.
Please. Malas, this is an application for the correction of the arithmetic
What?
calculation error.
What correction?
Malas,
It looks to be.
no, Malas, in paragraph 14, the amount which has been computed is 82 lakhs.
Correct.
If we go by the individual calculation which I have called out in my application at page 4, the total is 79 lakhs, Malas.
79,83,366.
Please, Malas, that's the difference. The difference of 3 lakhs. That's the only calculation error I'm saying.
Is it so?
Yes, Malas.
Huh?
I have no objections to the calculation. There's a difference of 3 lakhs. Well, 82 lakhs is being computed by the Sonam report, whereas the amount could be 79
It
lakhs.
is 79, 83,866.
Only arithmetic calculation.
Please, Manus, that's the only error which I'm pointing out. Please, Manus.
Total this is.
Manus, may have paragraph 2 and 4 of the application.
What was awarded by the tribunal?
Manus tribunal, I have called it out at page 6 of the
67 lakh 83,866.
Please, Manus.
What was the enhancement? How much?
12 lakhs is the enhancement.
12 lakh? Round up?
Please, Manus, rounded off 12 lakhs is the enhancement.
Then it comes to 79 lakh 83,866.
Whereas the judgment records 82 lakhs, Manus. That's the only difference I'm saying.
For us,
Manus, it provides in terms of the Supreme Court rules.
of
Manus.
all. Both the judges are available. To come before that bench.
Justice Anjali was presiding, Manus.
And my brother is also not the author of the judgment.
He is not the author of the judgment. I understand that. I also saw that in the morning, Manus.
Since the author of the judgment is not one of us, hence we direct the registry to list this matter before the appropriate bench after obtaining the orders from the Honorable Chief Justice.
Very well. Manus, I have one request. The insurance company has been acquired as of March of this year by Anderson International Holdings Limited. Manus, they may amend the cause title because now the company's insurance company is not Reliance anymore. If Manus would direct.
Okay, it will come up in that bench.
Make a request.
Make a request.
Because the remaining payment has already been made. Yes, the only question is with regard to the Sibal case. Thank you.
Item 11 plus 64.
Hey, please, Your Lordships. Lordships are aware that in terms of section 10 of the CPC, if there's a subsequent suit filed on
Madam,
the same issues,
you filed that civil appeal, 511 of 2000?
yes, that's the first appeal. Yes,
One, 3 questions.
yes.
In that civil appeal, which is still pending, you filed an appeal.
No, so Lordships, we filed the appeal from the judgment of the trial court. That appeal is allowed and my suit is decreed.
1 second.
The other
In
side-
that civil appeal, 511 of 2000,
Yes,
you filed an application for amendment
yes,
to seek for declaration challenging the sale deed dated 1995.
yes,
Now,
yes,
subsequently, after that appeal was allowed, which was in your favor,
yes.
you filed the second suit of
No, the suit is filed prior.
2084 of 1995,
No, Lordships, that is filed prior.
all prior suit.
Yes,
And in that suit,
yes.
again you are asking for the sale deed to be so and so to be declared as null and void.
So I'll just clarify.
Is it so or not?
So actually that suit is prior in point of time.
Assuming it to be so.
Because, yes. So originally the suit is of 86, qua a 68 sale. That's the
How is your second suit maintainable at all?
So the second suit was filed.
It is not only hit by order 2, rule 2, it is hit by section 10 also rightly.
Right. So so when we filed the 86 suit,
Yes.
it's only the 68 sale deed. That's all that was the subject matter of the first plaint. Now, initially the suit is dismissed. We file an appeal. While the appeal is pending, the defendants enter into these fraudulent sale deeds of 1995. That's a subsequent development. So first, we challenge the 1995 sale deeds in the second suit.
Why did you seek for amendment?
So, Lordships, I understand what the Lordships are putting to me, but the important fact is that after the amendment...
Please tell us, you
Yes.
pass the preliminary test, then you can take up the final exam.
Yes, I understand. The same questions, Lordships, I also asked. But the issue is, the reason why we are before your Lordships is that despite the amendment, there is no issue framed.
That doesn't matter.
No, I'll tell you the...
Parties were at addendum. Parties were at addendum.
No, Lordships. So I'll just give you, Lordships, a chronology. I understand your questions. So there is, Lordships have got this, there's a sale deed of 68, which the plaintiff, elderly lady, she challenges in 86, saying that her brothers-in-law have wrongly taken ownership over the property. That suit is dismissed. She files an appeal. During pendency of the appeal, the defendants in the first suit execute the 1995 sale deeds. She files the second suit of 1995 only qua the 1995 sale deeds. At that point, there is no challenge in the first suit qua the 1995 sale deeds. Now, subsequently, she amends, your Lordships are right, she amends the prayers in the first suit, but at that time, the matter is pending before the appellate court. The issues are never framed qua the 1995 sale deeds. So as a matter of fact, that never goes to evidence, that never goes to trial. There is no evidence led qua the 1995 sale deeds. That's an admitted fact. Now the appeal is allowed in my favor, but clearly there is nothing specific on the 1995 sale deeds, because when that appeal is decided in the first suit,
Second appeal is still pending?
is still pending.
Right, so urge all these grounds there.
So that we'll be very grateful if we could raise this before the second appeal. But I just
Tell the second appellate court, why should we scratch our...
just see 2 page numbers. First, Lordships, I know what your Lordships are saying. First, please see page 84 and 101 together. 84 are the issues in the first suit. Based on this issue will never go to trial. The fraudulent subsequent sale.
In your OS 2084, sorry, CS number 2084, what is the first issue? Whether the plaintiff proves that both the sale deed dated 13/3/1995 need to be cancelled.
Lordships, please see page 84.
Suppose,
Yes.
now let us go. First appeal you have succeeded, 511.
Yes.
Second appeal they have filed.
Yes.
In that second appeal
Yes.
is dismissed and the first appellate authority order is confirmed.
Right.
What will happen to the suit?
But if
Please tell us. You tell us, then we'll go forward.
that's right, then consequential prayers will be because there's
No, your suit itself, the suit itself will have to go.
but your Lordships,
Is it not so, madam?
in the event we lose, then the aspect of the 1995 sale deeds has never gone to trial. That's
Now that is the first issue in the second suit. Go prove it.
so let that be decided in either
You
suit.
can't have it check and it too.
In fact, Lordships, to the contrary,
Always.
the other side is a developer
Yes.
and he doesn't want this issue to go to trial.
That
Please
is,
see
we can't say anything.
162. Please see 162.
Rightly it has been stated.
Please see page 162. Because I am now neither able to frame an issue in the first suit on this, nor is the second suit going on. So as a matter of fact, this is what I wanted to show, 162. But the order starts at page 61. This is my
Application for amendment has been allowed in the first suit.
yes, but this is for framing of an issue pursuant to the
One
amendment.
second, in that suit,
Yes,
in the appeal you have succeeded.
yes,
It's only a second appeal.
yes,
Substantial question of law.
yes.
Seek for reformulating the substantial question of law. If you so desire.
No, Lordships, I'll just show this. I'll tell you why we are stuck.
You-
Because we both there are two sets of
Because
orders.
you thought you are most genius and you tried to do it in all the ways crisscrossing it.
Lordships, I bow down. That was in fact my question when I said, how could you? But Lordships, as a matter of fact, if there is no issue frame for the 1995 suit, then
They should have filed a suit, they should have filed an application not only under section 10, but also under order 7, rule 11.
Lordships,
So it was hit by order 7, rule 11D. Barred by any other law. which includes order to rule 2.
Right, Lordships. But just what we did is once his section 10 was allowed. Even ready to withdraw the 1995 suit if in the first suit these issues can be got.
Second appellate court.
Lordships, can I just show you, Lordships, one thing? Please see 162. Look at how on the other side, how they are using the process of law. This is when we make an application for framing of an issue in the first suit.
You know what is to be done. File order 39 rule 1 and 2 is that ask them to enjoin not to change the nature of the property. Do what you want.
The problem is that unless this issue is framed in the first suit and goes to trial, there will be no.
We took that risk. You took that risk. You are the dominus litis.
Lordships, but subsequently.
You are the litigant. You are the master of your ship. You should have navigated. You went into rough seas.
Lordships, we tried to rectify the situation by filing this application. Just see, please, 162. Please see this. We made an application. We are saying, okay, if you want to stay the second suit, then I must have an opportunity to lead evidence on the 1995 CLDs in the first suit. So I make an application for under Order 41, Rule 25.
Rule 20.
Additional issues.
Order 41?
Rule 25 to frame additional issues. Because
Where?
In the High Court where the second appeal is pending.
Second appeal.
Yes. And the Lordships have said that the second appellate court also has the authority under Order 41, Rule 25. Because by this time.
When was the property sold? After the suit was dismissed?
Yes, Your Lordships.
The first suit was dismissed.
When the appeal was pending.
When the appeal was pending.
Yes.
And then what? In the first appeal, how did you succeed in the first appeal?
Lordships, on the merits.
So by that time, your application for amendment was already allowed?
It came subsequent to that.
No.
Before that, 1 second. No, your Lordships are right. Your
Lordships 2002.
Yes, Your Lordships.
And civil appeal was allowed on 4 years thereafter.
Yes.
So if it was so, between 12/8/2002 to 31/1/2006, why did you not file Order 14 Rule 5?
Because the second suit was pending. Because the stay comes
You want to take chance in every litigation.
The stay comes 13 years later. At the stage of evidence.
If your application of Order 20
makes this.
Suppose the appellate court also were to feel,
Yes.
that is the second appellate court, wherein that application has been dismissed, it can exercise the power under Order 41, Rule 23, Rule 24, Rule 25. All the three. Now your application was under Order 41, Rule 25.
Yes.
It has been dismissed. Still, it has got the power of Order 41, Rule 23. Subject to the substantial question of law being there, or you raising the substantial question of law, it is for you.
Lordships, if that can be left open.
We will not say anything.
You see what the other side does, it's approbate and reprobate. In one proceeding, please see what they
They are approbating and reprobating, but your suit itself is not maintainable.
Lordships, in the first instance.
If you want us to make that observation,
no. Lordships, I have instructions. We are willing to withdraw the second suit, but let the issues be adjudicated in whole, incomplete. That's all we are saying.
Go tell the appellate court. Go tell the appellate court. Ask for remand. Do whatever you want. Once the written statement is amended, plaintiff is amended. What is that you are required to do?
No,
what was the appellate court required to do?
There should have been issues framed. That's right. But Lordships, because the other suit was pending at that point, because the other side also came into action only 13 years later. At that point of time, the other suit was pending, evidence was going on.
And subsequent bona fide purchases.
No, they're not bona fide. In fact, it's completely flawed. They've not even paid the full consideration. They've paid peanuts.
If you don't succeed in the second appeal before the High Court,
yes.
When you come there, we'll examine. Not at this stage. Thank you. No grounds. Both serial number 11 and 64 dismissed.
Can you make this application, Your Lordships? If Your Lordships will leave it open for us to pursue this before the second appellate.
Which application?
Make a fresh application under Order 41, Rule 25. Because what's
your application is already dismissed.
After that, the second suit has also been stayed.
Naturally.
And
now the second appeal is pending. Seek for disposal of the second appeal.
But Lordships, with this issue will never go to trial.
We do not know. We do not know. Then you are succeeding in the appeal because that means goes to show that you could not have succeeded in the first appeal.
No, Lordships. The subsequent.
Now defend the judgment and decree in second appeal.
The subsequent sale is totally different. It happens much later. My merits in the suit, in the first suit, are based
Sorry,
on the
ma'am.
68 sale. All I'm saying is,
Thank you.
we have been left high and dry for the 95.
Yes.
That's all. And how can there be a stay, Your Lordships, when it is not framed in issue? When there's no issue framed on that. That's the only
Substantial issue in question. Section 10 says substantial issue between the same parties. Property same, parties are same, and substantial issue are same. All the three ingredients of section 10.
Lordship sees 162. My application to frame an additional issue is dismissed on the basis that the second suit is pending.
Thank you.
Subsequently, please.
No grounds. Dismissed.
Your Lordships have been extremely patient with me. May I just show one last document, Lordships? Then I will.
We are extremely patient, but don't make us patient.
Lordship,
Next, that's all. Thank
only
you.
just one para in page 162. If I can just show.
All. Before dismissing once again, let us look at parliament.
I'm extremely sorry, but I'm just praying for Your Lordship's indulgence.
All.
I would not press, but Lordships, there appears to be some lacuna here.
Yes, sir. Lacuna from your side.
No, Lordships, that is true. We have.
No, you is not you, your party.
I understand. But Lordships, we are requesting your Lordships to exercise the power under Order 41, Rule 25. At least protect us to that extent.
Not at this stage.
Because that's the
you don't
second-
succeed in second appeal, then we'll examine whether the dismissal of order 41 Rule 25
Yes.
was justified. In fact, Order 41 Rule 25, please read.
Yes.
Order 41 is governing the provision of appeals, not the second appeals. Mutatis mutandis it will not apply. Some cases it will apply.
Yes. So your Lordships have said that this will apply even at the second appellate stage and even before the Supreme Court. I can place those judgments. We're carrying copies. So if you see Lordships page 162, this is the dismissal of our application under Order 41 Rule 25. Para 2.
Paragraph?
Para 2.
All.
The other side, that is them, para 2, the other side resisted for framing additional issues by contending that substantive suit, that is special civil suit number so and so, this is the second suit, filed by respondent number 1 is pending for adjudication, wherein the same issues are already framed. So when we sought to frame these issues in the first suit, the other side says, sorry, they are already framed in the second suit. So they oppose this. Now please see para 7, which is the concluding portion at page 164.
Sale date is dated 13/3/1995.
Yes, Your Lordships.
Come to the first appellate court judgment of the first appeal where you succeeded.
Yes.
Page number 98, paragraph 61.
Yes, Your Lordships.
Now you invited trouble.
Your Lordships, everything is before Your Lordships. We are only requesting Your Lordships to help us.
Yes.
95 sale dates. Para 61.
61. Defendant number 4 is the purchaser during the pendency of the suit.
Yes. Yes, Your Lordships.
Read it.
He cannot claim anything more than the right of defendant number 1 in the suit property. As stated above, plaintiff is the real owner of the suit property, that is me, and defendants number 1 and 3 are benamidas. Therefore, defendant number 1 has no right in the suit property, and
The defendants
therefore,
1 and 3 are the brothers of your
yes,
husband.
yes, exactly.
Right?
Yes, absolutely.
So it is held to be benamidas.
Yes.
So now, therefore, defendant 1 has no right in the suit property, and therefore, defendant number 4
Yes.
not get any title in the suit property by virtue of the sale deed dated 13/3/1995.
Yes, Your Lordship.
Make use of it. What is this, madam?
Very well.
No grounds.
This is under challenge, Your Lordships.
That issue is there in OS 2084. That is the first issue.
Say that dismissed at
Produce the judgment. Put your witness into the box. Say this is the judgment and decree. I close my side.
We won't be able to place any witness, Lordships, pursuant to this order at page 162. That order at page 162 is the subject matter of challenge. They have a second appeal, second SLP, which is item number 64. So that says you cannot raise fresh issues. And this impugned order in the first SLP says
Because
stay.
that issue is, even though not raised, in the first appellate court,
It is
under
implicit.
order 41, rule 19 or 21.
Yes, sir.
This point has been formulated, answered in your favor, and now it is for them to demolish your case. They have got an appeal task. Why do you worry? You are unnecessarily bringing trouble on yourself. Don't do it.
Only thing is,
If you
Lordship,
don't succeed in the second appeal,
yes, yes.
you come obviously you will have a better case, then we'll examine.
Then Lordships, just one phrase to that extent, that's
No,
all. They
not
only-
at this stage.
we say at
Not
this
at
stage.
this stage.
We only say at this stage, so that Lordships at a subsequent stage, we are
We
not
can't
bound
say,
by
we can't say,
this.
because it's a second appeal, it has been admitted, it is pending.
Yes.
You are there, you don't succeed, then come here, we'll examine. All right? Thank you. I can call.
Lordships, I'm sorry, but I'm instructed to withdraw this now, Lordships, both the SLPC.
At this juncture, the learned senior counsel submits a praise for withdrawal of the petition on instructions. Hence, petition is dismissed as withdrawn.
Maybe for liberty to file a review. Only
No,
for special edition.
no. You ask, we'll record it and reject it. You want it?
No, Lordships. I'm very grateful. I think I'm extremely grateful, Lordships, for the patient here.
All right. Next. I can call.
Under item 12, your state is in SLP. Malatri, my intra-court appeal was dismissed on the ground of delay. Now, Malat, there's one problem. Malat, the single judge, the delay was of 508 days, Malat.
Yes.
Malat, the single judge order is at page 65, P9, Malat.
When did your Office of Advocate General receive the copy of the order?
Malat, that's the one at page 77 is the delay application, 76 is the delay application.
When did your Advocate General Office receive it?
November, Malat, is the date.
All right, we'll give you the date, 25/11/2024.
That's right, Malat.
And the opinion was given by the learned
There's a
Advocate General on the very next day,
opinion. That's right.
26/11. And you sought the permission only on 9/4/2025.
That's right.
So what is that?
The
What is
opinion?
the explanation given?
There's no explanation. There's
Oh.
no explanation. Manoj, it's
Oh.
not there. I cannot. In para 4 afterwards, it's the High Court says, Manoj, post the opinion when it was sought. The permission for grant was granted in April 25.
That is the second stage of delay.
That's right.
First stage of delay.
I follow.
4/9/2023
That's
is
clear.
the order. So from 4/9/2023 to
There's nothing.
25/11/2024,
It's
what did you
nothing is written in the application.
Two grounds.
Manoj, are the problems? Manoj, the High Court, Manoj, on merits, if I may say so. Manoj, at page 65, P9 is the order. Manoj, the single judge, the learned single judge, Manoj, relies upon an order of a writ petition in this case of Seema Raizada.
WP 4863 of 2000.
Manoj, I can demonstrate from this order is also.
Don't venture into that.
Manoj, it's absolutely a different case. No rules, Manoj, this particular was an ad hoc appointment. Manoj, this is a problem, serious problem. What has happened in Seema Raizada's case?
All right, we'll protect you from any future. Only the peculiar facts of this case we'll say. Having heard the learned counsel appearing for the petition, among the peculiar facts and circumstances of the case, we are not inclined to entertain the petition, hence dismissed.
May not be treated as a precedent.
We will not say that. Peculiar means you should understand. Take note of
The
it.
problem is the case was absolutely different. So,
Item 13.
Item 13, I'm praying for 2 weeks' time to amend the SLP for the reason that after this impugned order, review was filed and order has been passed in review. We have
At request of petitioner counsel, list after 2 weeks.
gratefully. My lord, with permission to amend, otherwise registry won't allow. Permission to amend the
On the ground that the review, during the pendency of the present petition, the review petition which had been filed has since been dismissed.
No, my lord. The review was dismissed even before we filed the SLP, but by oversight.
On the ground that the review petition has been dismissed and they intend to challenge the same. Hence permitted to file the application for amending.
Review petition, writ petition was allowed, review has also been allowed. So now we need to impugn the review, order of review.
That is what?
Right.
Challenge that. Now then what order you have challenged?
The first order was reinstatement, my lord. Now in review, they've said because he has superannuated, give him all the pensionary benefits and all. So that we want to impugn.
Yes.
Grateful.
Item 40, we were contemplating of issuing notice to you as to why you could have refused back wages.
No, my lord, the honorable.
Because this order does not say back,
No, it doesn't.
no back wages. So you filed the review.
No, my lord.
Yeah, both fine.
No, my lord. एक second.
The other side filed.
My lord, the Honorable High Court directed reinstate him without back wages. Then he filed a review saying that he has already superannuated, he can't be reinstated, so give me pensionary benefits. So the Honorable High Court on his review petition modified the order saying because he can't be superannuated, so give him pensionary benefits. That.
All right, take your chance. We will dismiss it on the next.
No, my lord, I have something.
Simple. Have you examined the complainant? So what is your charge? Your charge is that he took money, 40,000 rupees, demand and acceptance. Whether there is a demand or acceptance, what is that minimum you are required to do? Examine the complainant, all right. Leave the complainant.
In the
Some intermediary who came in to act as a tout, did you examine? No.
But the officers went to his residence. In fact, the complainant was.
The only thing redeeming factor is that he wrote a letter saying that I am sorry.
Yes, my lord.
That you want to make use of it. Not in a DE proceedings.
Not the DA proceedings, CAT, everybody is dismissed with reason.
No, only DE is held because they are your officials, we know. And so far CAT is concerned, CAT is dismissed and rightly the learned single judge has interfered with that.
I'll make good my submission on the next day. Grateful.
Item 14. Please, my lord, I'm appearing on response number 3 by way of caveat, my lord.
Please, Lord, I humbly present the petitioner in the present matter, Lords. He is a 80-year-old man, Lords. He is in the possession of the suit property since the last 41 years, Lords, is what my humble submission is, Lords. What happens is, Lords, till for the next 60 months, since 1984, he is in possession, Lords. 2005, Lords, respondent number 1 comes to him and says that he is the GPA holder in favor of respondent number 2 has executed a GPA in favor of respondent number 1, and he can sell the suit property to me. So, my lords, I advance a sum of 25,000. This is also corroborated by the evidence. Oral agreement, lords. And the witnesses have also corroborated the fact, lord, that I advanced the money. I am in possession, lord. This is also proved, lord. Learned, lord. Courts have also concurrently held that I was in possession of the suit property since last so many years, lord. I advanced the sum of money, lords. The rest 75,000 also I was ready to pay, lords. The total agreement was for 1 lakh rupees, lords. What happens is, lords, in the meanwhile, lords, he goes into an agreement with the respondent number 3, lords. What happens is, lords, I send representations and letters to various officials that this mutation should not be done since I have already advanced the money. I sent him the legal notice, lord, that you should execute the agreement in my favor, lords. Thereafter, lords, I filed a suit in 2005 itself that for specific performance, lords, that the agreement should be executed in my favor, lords. In the alternative, lords, I humbly seek, lord, my 25,000 with interest, which I advanced as earnest money, should be refunded to me, lords. However, lords, he files his counter claim, lords, in the matter, lords. Both my suit and the counter claim is dismissed, lord, till the second appeal, lords. Lords, what happens is, lord, in the second appeal, lords, when the respondents, lords, challenge the counter claim dismissal, lords, before the Honorable High Court.
After the suit was dismissed, first appeal.
Please, lords. In first appeal also, lords, my suit is dismissed. Their appeal is dismissed, lords, and my appeal is also dismissed, lords. First appeal, lords. Thereafter, I also go to the High Court.
The defendant's claim was on the basis of a registered salient and a court authority.
So what?
They did not produce that.
They did not produce it because the Honorable High Court not till I filed the suit in 2005, lords. For the next 19 years as well, they didn't produce the GPA as well as the registered.
When was the first appeal dismissed?
Lords, the first appeal was dismissed in 2016 itself, lords.
What date?
Lords, 3/11/2015, lords, is the order of the DJ.
When was the second appeal filed?
Second appeal was filed, lords, by the respondents, lords, in 2015, lords.
Yes. And when was the application filed?
Lords, the application was filed after a delay of 19 years, lords. After that, 2024 itself. 2024.
In second appeal.
In second appeal, lords, they filed this application.
In 2016, the second appeal, Order 41, Rule 27,
please, lord,
along with 2 documents.
So
which are registered documents.
This application, lords, is what my humble submission is. Lord, they filed it in 2024.
Please read the proviso to Rule 27 of Order 41.
So, lords,
in the interest of justice, substantial justice.
Please, lords. However, lords, their conduct is also, lords, very, very suspicious, lords. He files it in 2020.
Registered document. There is a presumption under Section 8.
This application is also dismissed by the Honorable High Court, lords. High Court says that even in absence of these documents, lords, this should be declared in favor of the respondent number 3, lords. My humble request is, lords, neither the scribe nor the registrar, lords, have been examined, lords. This possession is also never proved, lord, by him. His ownership is not proved, lords. Before the learned trial court, lords, 2 courts have concurrently held in in favor that respondent number 3 is never in possession of the respondent of the sued property, Lords, and his ownership is also not proved. However, Lords, High Court has unsettled these findings, concurrent findings, Lords, and respondent number 3 has been given possession from me, Lords, after enjoying being at the property from last 41 years. This possession has been given to respondent number 3. However, this possession is also concurrently held by learned courts, Lord, that adverse inference should be drawn against the respondents. Lords may have Lords page 133, Lords, for a moment. Lords. 133 is the dismissal of the trial court order, Lords, where the suit was dismissed, Lords. 133, Lords, para 8, Lords. May I read, Lords? This is the recorded finding of the trial court, Lords, that since documents were never produced, the ownership was not produced, Lords, Honorable Lords, learned Civil Judge Senior Division, Lords, goes
You yourself, in your own plaint, you are admitting his title. Section 56 of the Evidence Act.
I am admitting the title of respondent number 3, Lords.
Where else?
Respondent number 2, Lords. Not the title of respondent number 3. I say that I was into agreement with the respondent number 1. He defrauded me for 25,000. He is not showing
Thank you, sir. No grounds, rejected.
In that case, not if I may humbly request, not my the amount which I.
What they can't do, file is do what?
My lord, the agreement of sale is held not to be proved, my lord. I am entitled to mean profits, my lord. He is unnecessarily enjoying that property, my lord, without any title, agreement, anything.
Have you a degree? Do you have the degree for mean profits?
No, my lord. Only possession is directed.
I will not see. Was possession also.
Shall we take that you are contending now?
I'm sorry, my lord. I will take back my argument.
Adverse possession has been not.
So that we can admit and issue notice.
Please, Lords. And 21 years, Lords, have passed after, and I am the one who files the suit first and makes all the complaints, Lords.
You have failed to prove the execution of the agreement itself.
Please, Lords.
And on the other hand, you seem to be too honest.
Please, Lords.
It looks like it. Might be, you might be correct also.
Please, Lords.
You admitted his title. Thank you. No problem.
I'm so good. So good.
Oblige, my lord.
Letter is there, adjourned.
Item 16.
No, this was a batch of matters before the High Court, and we have said we never received notice. Kindly see, we also examined the PDF. We called for the entire PDF of the High Court. We've said so categorically, more that
We have issued notice in that.
you're sure if you notice in the main matter, Ramphal, order is placed on record, not last page of the paper book, which gives rise to that question of law. Co-sharers.
Issue notice, post along with SLP civil number 4532-4539 of 2023 and SLP dairy number 6649 of 2020.
Lord, there is therefore a delay because no notice. We came to know only on 15th of July.
How much is the delay?
Lord, that's 1,000 days delay.
Issue notice on delay and both.
Lordship, yes. Very great. Yeah. Lord, there is one thing I must point out, Lord. Some averment at page of list of dates KLN is erroneous. Lord, permit me to correct it.
Huh?
There are some averments that we filed the appeal, the government didn't file an appeal. We want to make that correction. Let it not be taken as a.
No, because
yes,
the presumption here is
yes,
what you say is incorrect. Sorry for saying this. We like to do our own homework. We like to spend our extra hours on these things. So it doesn't matter for us. So you bring it to our notice, revise it, file it at that point of time when the matter is taken up for final disposal.
Just permit me to file another another synopsis. That will be enough.
This is what now some or the other take it.
It's not very material.
Order from the court and then say it's mistake, sorry.
Just to obviate an objection from the other side, we'll file another no correction, nothing. Another.
Let the other side also have a right to raise their objection. Next.
Item 17.
Lordship, yes.
Yes.
Lord, this is an income tax matter, Lord.
Yes.
And the matter is reassessment. Lord, two issues are there. One as to whether the TOLA, Lord, the taxation of release Relaxation Provision, my Lord, Act, which extended the income tax periods, my Lord, of limitation from March 20, my Lord, to 31st March 21.
Yes.
And there is one suo motu case, my Lord, which the High Court has referred to, my Lord, in the suo motu writ petition. I may state, my Lord, that under that judgment, suo motu case, my Lord, the time limit was extended till March 2020, February 2022, and then further 90 days, my Lord. My Lord, this is the assessment year 2020-21, for which, my Lord, the limitation expires much beyond the COVID period in March 2024. What the Honorable High Court, my Lord, at page 32, paragraph 40 has done in the order, that they have added the period of COVID time, my Lord, to save the limitation of this year, my Lord.
Raise all these issues in 260 appeals, sir. Not now.
My Lord, I am at 148A-D proceeding,
Yes.
my Lord, and the second issue is of sanction, my Lord.
At the
Lord,
drop
we'll
of
see.
the hat, 148, when it is invoked at the drop of the hat, you will approach the 226 code. Sorry.
Lord, one thing, in the Rajiv Bansal case of this Honorable High Court, my Lord, in paragraph 75 has held, my Lord, that this issue goes to the root of the jurisdiction, my Lord. Both sanction also, my Lord. The sanction, my Lord, beyond the 3 years period, my Lord, has to be of the principal chief commissioner, my Lord, and not of the PCIT who gave sanction, my Lord. And a recent judgment of the Delhi High Court, my Lord, in the same matter, that extension of time will not, my Lord, change the sanctioning authority. So without a sanction, my Lord, appropriately having been made by a proper sanctioning authority under 151 subclause Roman 2, my Lord, of the Income Tax Act, my Lord, the whole sanction is without jurisdiction, renders the order without jurisdiction, my Lord. And this is what precisely is held, my Lord, in...
It is not a notice issued under 148A-D. It is a notice issued under 148A-A.
No, my Lord, it is a notice under 148A-D, my Lord, holding it to be a fit case for issue of notice under 148A-D.
Thank you.
Kindly see the judgment. Kindly see the...
We are not interfering. You raise all this in your 260 appeal, if at all, if you are aggrieved. No grounds.
Not.
Next.
Please, Your Lordship. My Lord, this is a point.
Absolutely right. Absolutely right.
My Lord, Life Insurance Corporation is under the Act. This is LIC.
It is an instrument, BCCI and all these.
Correct, my Lords. BCCI, they must
perform. Element of public duty you are discharging, sir.
Correct, my Lords. But there are judgments, even the Karnataka High Court, my Lords.
Yes, which was?
Srinivasulu, which is mentioned.
Whether they are referred to Mysore paper mills in that, it's a larger bench judgment of this court.
No, my Lords, they have.
Yes, Mysore paper mill, similar issue. I am telling you why. I appeared and I lost it. That is why I am telling you.
Let me make some endeavor to do, my Lords.
Our attention was, it is not an instrumentality of state. However, it was referred to the larger bench. The larger bench of the High Court, there presided by the Chief Justice. No, it is an instrumentality state. We challenged that before this court. It was dismissed. 48%. Whether it is a government company under section 617 of the Companies Act or not, that was considered. And yes, where instrument, if there is an element of public duty being discharged, that is sufficient.
Correct.
And you are saying this is the whole subsidiary of Government of India.
LIC is, my Lords.
No, LIC Corporation. This is a company constituted under the Companies Act.
This is a company constituted under the Companies Act. LIC has 45% stakeholding, shareholding in it.
Yes.
So, my Lords, LIC
is of association. It is absurd. It is a company established under the Companies Act and against the column promoter.
Correct.
LIC has been specified as Life Insurance Corporation of India.
Correct, my Lords.
And also, it has been referred to as a statutory corporation established by and under the LIC.
So, my Lords, LIC, your Lordships are aware, I needn't endeavor much. LIC is under the Act of 1956.
Correct.
So, that is, my Lords, it is a statutory corporation. LIC is a statutory corporation. But, my Lords, LIC HFL, LIC Nomura Fund, there are umpteen number of funds and all these in which LIC has stakeholding, my Lords.
And you want to get away from this being an instrumentality of this case.
even otherwise under that rule also 12, I can also demonstrate that that's also incorrectly held. That I can, but I'm not getting into that. I'll try to endeavor to
Do it, please. Please do it.
it becomes difficult.
We may be
Anyhow, let me endeavor.
we
I
may
know.
be persuaded by your endeavor.
My lords, my lords, since the lordships have said, my only argument on it being an instrumentality of the state is that merely because it has 45% holding in LIC HFL would not make it state under Article 12. Your lordships test in that Pradeep Biswas, my lords, Ajay Hasya, Khalid. I'm not even getting. So, my lords, the test, I agree, my lords, your lordships are right there. I'm not saying that the function should be there or not. But the point here is, my lords, you will also have, lordships will also have to kindly see that, my lords, what is the stakeholding? It's not even 51%, my lords. It's
48.5,
45.
We'll tell you once.
45. Lords, kindly come to the impugned judgment.
45.20.
It's 45.24.
45.24.
Correct, my lords. So it says that it is almost close to less than 50. So that is how the division bench says.
The four tests, all the four tests tick. Thank you. No problem.
All right, my lords, then in that event, my lords, then kindly hear on Rule 12, my lords. That's pertinent. Because, my lords, then in that event, my lords, kindly see. Rule 12, my lords, it is quoted in the impugned judgment. I will not even take my lords to the... Kindly see Rule 12, my lords. It doesn't... My lords, kindly come to page I, my lords, of the SLP paper. A faint attempt, my lords.
We are rather surprised. See, even in a case of an employee who tenders his resignation, his right to withdraw will be there. And once he withdraws, whether the question of you are rejecting it?
No. That's why, my lords. Kindly see the rule then, my lords. Now that your lordship, I will not even get into instrumentality. Kindly come to page I. I think I can convince my lords there. To kindly come to page I, my lords. Page I, my lords. The synopsis page I.
Yes.
Kindly come to page H. I'll just show, my lords. It shows Rule 12. Resignation stroke termination, my lords. 12A, that's not required, my lords. Kindly come to 12F. In case of resignation, comma, my lords have got that.
Yes.
Yes,
sorry.
it's quoted in the
Yes, my lords. It's quoted in the judgment also. In case of resignation, comma, an employee who has elected to resign under this rule and has given necessary notice to that effect to the appointing authority. One is, my lords, he doesn't give it to the appointing authority. Anyways, shall be allowed to withdraw his or her notice with the specific approval of the appointing authority, comma, provided that the request for such withdrawal shall be made on or before the expiry of the notice period. Shall be allowed to withdraw his or her notice with the specific approval of the appointing. He doesn't have the approval of the appointing authority to withdraw this, my lords.
See, on what ground did he be rejected?
Kindly come.
Come to page number 87.
Yes, my lords. We'll come. My lords,
first rejection is 87, 88.
Yes.
Second rejection is 103, 104.
Yes, my lords are right. Kindly come to, my lords, page 83. No, I know. Acceptance of first acceptance, my lord said 83, and then kindly come to 87, my lords. 87 is the relieving letter, my lords.
No.
103, which my lords right.
Yes, 103.
103, my lords. Right. Kindly see, my lords. Further to your trailing mail, kindly refer our email dated so and so sent on such and such. My lords, he sends it at 11:40 in the night. The contention of which are mentioned below, email dated. This is with reference to the trailing mail note dated so and so on the above subject. Please note, my lords, it's missed out that it has not been found possible to accept your request.
What? Why? How? Reason? Is there any total non-application of mine?
My lords, as I said, that 12, my lords.
Yes, 12.
That is the ground, my lords. 12F, because my lords.
12F mandates that there should be some application of mine.
So, my lords, kindly now see the same, my lords. 12F, it says allowed to withdraw his or her notice with the specific approval of the appointing authority. There is no approval.
Many times it so happens that at particular point of time, he was,
my lord, joined as a management trainee, then assistant manager.
So it was at a managerial level.
Yes, my
There
lord.
will- in these departments, there will be a lot of pressure of recovery, NPAs, and all these. This is housing finance.
My lord, his ground is he wanted to write CFA exams. Then, my lord, then the COVID came. He thought that he could not write the CFA exam.
He thought he will progress in life. For obvious reasons, he could not. Now you can't throttle him like
My
this.
lords, but
Don't throttle him like this.
then, my lords, kindly come to the direction, then kindly at page 15. Accordingly, we set aside orders dated, consequently, judgment under challenge, direct LIC to treat the petitioner to the roles of LIC HFL and pay all consequential benefits.
Rightly so.
Look, consequential benefits, why should
Yes.
somebody who's not worked, my lord? It's not that
No, it can't be no work, no pay. You did not. You prevented him.
my lords,
You prevented him.
then my lords,
You should
12F, I showed that, though my lord said that, no, even we will not.
But
my lord, at least
is he still in service?
Look, he's right now, he's not taken
No.
after this judgment, he's not taken.
No, whether
He has age.
He has got age.
He's got age. He's got age. But my lords, then in that event, if he'll be taken into service, consequential benefits can be given. Your lordships are.
LIC is doing very good, paying. Right?
No, my lords, a lot of allegations. This is LIC HFL, my lords. This is HFL.
Yes.
Please see the direction, my lords. The direction is now to LIC to treat him on the roles of LIC. The direction is not even to LIC HFL. Kindly see the
It
direction.
is the obvious, sir. It means. Sir.
This is, my lord, just because LIC has a holding of 45%, even LIC will only treat him on the roles of LIC HFL.
No,
Please
no,
see the direction.
No. To the see, please
Read the
direct
petitioner.
LIC to treat the petitioner to the roles
LIC
of
has no
LIC.
business to treat, my lords, the
And
petitioner
to
on
pay,
the roles. My lord.
whether LIC was a party or not.
My lords, LIC is not a party. My lords, I'm told LIC will prefer SLP as against this. I will make it.
There we look into it.
Then, my lords, may not just keep it pending, my lords.
LIC is a party and respondent number 5.
No, my lords.
See, please see. Page number 2.
Subsequently, I know. Subsequently, my lord, by way of an impediment.
Sought to be implemented.
Sought to be implemented.
We'll let LIC come, we'll consider. We'll say it.
Then, my lords, in fairness, then just let this remain, let it not be dismissed. If it is dismissed, LIC will also have a problem. Maybe I might come for LIC and then maybe in a position.
All right.
Just keep it.
At request of petitioner counsel. Heard the learned counsel appearing for the petitioner. At his request, adjourned by 3 minutes.
Deeply obliged. Deeply. Obliged, my lords, for a patient hearing.
Item 19.
Well, sir, take your 2 minutes. Let's, I have one point to show. Let's kindly have a look at page 211.
Yes.
The grievance, my lords, of the contesting respondent was he was not promoted from scale 3 to scale 4.
Yes.
Scale 3 to scale 4, my lords, there was an earlier round. There was a direction, my lords, to exclude 2012 APAR and then consider. Insofar as that is concerned, my lords, the court has taken the view that subsequent holding of an interview is bad, and therefore, my lords, they said that you could not have not promoted him from scale 3 to scale 4.
Yes.
My lords, insofar as promoting him by this impugned order while doing equitable justice, to promote not only from scale 3 to scale 4, but scale 4 to scale 5. Scale 5 or 4 to 5, the requirements are detailed at regulations, guideline 7 at page 211. It starts at 210 minutes at 211. Scale 3 to 4 is 1. Scale 4
So, Prabhupada, which are the 3 years which you considered in the earlier?
Well, it's 2012, 13 and 14. 12 was not to be considered as what Muller's was directed because I understand there's a direction to hold a separate DPC.
For excluding 2012.
Correct. Muller's, I got it. I'm not even joining issues on that. Muller's,
That's all.
No, again, thereafter, they have given one more promotion.
Automatically you are entitled. You denied him the 3 because you took into consideration 2015-16.
Correct.
So they said nothing doing when he is because the other aspect also which has been noticed is that
Kindly have a look at notes. Well, doing equitable justice is what the court notes.
1 second.
Para 19, my lords, at page 12.
2015, 16, 17, he has scored 88%, 86%, and 90%.
Correct, my lords.
And his APR also for 13, 14, 15 for 90, 75, and 88.
My lords, I have no quarrel on that, my lords. But the point is, my lords, just by getting it, my lords, he is entitled for being considered. Whether he's being entitled for being promoted, my lords, have they taken the view. Promotion is not a right. Consideration is definitely a right insofar as 4 to 5 is concerned.
Yes.
Kindly see, my lords, what they do is, now he has retired in 2021.
Yes.
With retrospective effect, the promotion is given from 3 to 4. My lord, that I bow down to, my lords, because my lord's direction was to hold a review DPC by excluding that. So therefore, my lords, I'm not going to urge that. But 4 to 5, the requirements are different. They have to take other exams. Kindly have a look at page 211 in that context, my lords. For that reason, I'm pointing out 211.
He was in the zone of consideration at that time.
Well, no, that's why I'm saying. Kindly have a look at 211.
He was branch head of.
No, he was not branch head. That's also
You gave him certificate, your age. DGM gave him a certificate.
He was senior manager, not branch head. My lords are right. That's what is noted. In fact, my lords, the requirement is he should be a branch head. There is a
zonal manager on 19/11/2019. He received a certificate of appreciation by the zonal manager.
Correct. 4 lords for being a senior manager.
And he was deployed as a chief manager, which was, and he was deployed in the Malabar East branch, City Bank office, Mumbai, as a chief manager, which was actually a post to be held by scale 4 post.
Well, it's scale 4, I bow down. That's what I'm saying. I bow down for scale 4. Scale 5, my lords, there are different requirements. It does not mean, my lords, automatically, even without passing those exams and, my lords, qualifying, he would be entitled. He worked under scale 4. The other requirements, kindly have a look at for a minute.
When did he superannuate?
21.
21. So automatically in 2018, after 3 years, he was eligible.
No, but in 18, you would have completed, but requirement for scale 5 is different. Kindly look at clause 7 notes at page 211. These are the requirements. May I read that notes with my lord's permission?
211 is it?
11 notes. The guidelines for promotion in public sector undertakings is issued, my lords, by the Ministry of Finance. Page 210, it starts at 211.
Yes.
My lords have 7. Promotion from scale 4 and above. For promotion from scale 3 to 4, which is what, my lords, I have conceded, 4 to 5, it will be mandatory to pass an examination for computer literacy and computer knowledge. Second, my lords, for being eligible for promotion to scale 5, the candidate should have been branch head for at least 3 years. Then, my lords, kindly look at 5. It shall be mandatory to have a group discussion